Hi, for those who weren't here this morning, I'm Theresa Harris, and I'm director of the AAAS Center for Scientific Responsibility and Justice. And I get to introduce the featured speaker for this evening to close out the day. The Honorable Jed S. Rakoff will share his experience and views on how the scientific and legal spheres intersect and how we can strengthen cooperation between the scientific enterprise and the justice system. Judge Rakoff has served since March 1996 as a U.S. District Judge for the Southern District of New York. He frequently sits by designation on the Second and Ninth Circuit Courts of Appeals. His most noteworthy decisions have been in areas of securities law and criminal law. He is also an adjunct professor at Columbia Law School and New York University School of Law, and teaches at University of California, Berkeley School of Law and the University of Virginia School of Law. He has written over 180 published articles, 835 speeches, and 1,800 judicial opinions, and has co-authored 5 books. He's a regular contributor to the New York Review of Books and author of Why the Innocent Plead Guilty and the Guilty Go Free, and Other Paradoxes of Our Broken Legal System. Relevant to his remarks today, Rakoff served on the National Commission on Forensic Science and as co-chair of the National Academy of Sciences Committee on Eyewitness Identification. He also served on the governance board of the MacArthur Foundation's Project on Law and Neuroscience, and on the Committee on the Development of the 3rd edition of the Reference Manual on Scientific Evidence. Please read his full bio online with the speaker bios. It goes on, and if you are looking for inspiration on how to lead an exemplary professional life of public service, that's it. After Judge Rakoff's remarks, we will have some time for questions from the room and online. If you're online, please add your questions in the Zoom Q&A box anytime during the presentation, which will give us some time to get those questions into the queue here in the room. Judge Rakoff, the floor is yours.
Well, I want to thank Theresa for that very kind introduction. I'm very grateful that my wife is not here because she would demand rebuttal time. Before I get started, I have to make a disclaimer. Under federal law, I am forbidden from commenting on any case that's pending, not just before me, but before any judge, and also from commenting on any issue that's likely to come before me for decision in the immediate future. So that concludes my remarks. Thanks very much. Well, maybe not. I'm sorry that because I had a ongoing jury trial that I wasn't able to be here for the earlier part of this session, and I know many of the speakers, and they were all quite extraordinary, so I'm sure you've had a very valuable day. I'm not going to use any PowerPoints. I noticed that the last panel, which I did arrive in time to see, had some difficulties with their PowerPoints, but that's nothing like the difficulties I would have. Some of you may know this, but it's a requirement to be a federal judge that you be technologically incompetent, and I qualify completely. Anyway, I suspect that some of the earlier speakers may have said something about what I want to really talk about first, which is how in the last 35 years or so, the way in which judges have come to view their role in dealing with scientific issues has changed substantially, even dramatically, but not always in the same direction. This is most obvious in the case of forensic science, that is, crime laboratory findings that are introduced in court by experts. Some courts have become highly skeptical of certain kinds of forensic science, such as microscopic hair analysis, blood spatter analysis, bite mark analysis. But other courts have become convinced that such evidence is so reliable that courts can take judicial notice that they are good science. This is not just a continuum of views, it's a stark divergence between the courts. And the question then is, what accounts for these radically different views, and what might be done to improve how courts deal with not only forensic science, but science in general. To put the matter in the very broadest perspective, if the rule of law demands a reasonable degree of certainty and predictability in how courts treat recurring issues, it has to be said that how courts currently treat scientific issues does not qualify as the rule of law. And that's pretty, at least to me, upsetting. And given how hugely science has come to affect our lives, not least our legal disputes, this is a very serious shortcoming that cries out for improvement. But first, and again, I hope I'm not repeating too much of might have been referred to earlier today, but let me illustrate the problem by reference to forensic science, where the failure of the courts to deal in a consistent and convincing fashion with the problems such evidence presents has become little short of scandalous. In my view, the widely differing approaches that courts take to forensic science reflect in turn their widely varying reactions to three major developments in the last 35 years or so. The first development, beginning in the late 1980s, was the introduction of DNA profiling evidence in criminal cases. Unlike most other forms of forensic science, DNA profiling was first developed not in police laboratories and not for the purpose of criminal investigations, but as part of the study of genetics in universities. One result of such studies was the discovery that every person has a DNA profile that, except in the case of identical twins, can, by use of now well-established techniques, be differentiated from other people's DNA profiles to a high degree of probability. This was, as I say, first discovered in university studies of genetics, but eventually it became known to those who dealt with forensic science, and as a result, beginning in the late 1980s, DNA matches, technically calculations of a high probability that two DNA samples come from the same person or not, were introduced by prosecutors in criminal cases as strong evidence of a defendant's participation in the crime in question. This was by the prosecution. I'm not sure where the very first such case occurred, but I know that one of the earliest occurred in 1988 in Manhattan in the state courts there. Not much later, however, in cases where the DNA samples were found not to match, the very low probability that the two DNA samples in such a case came from the same person began to be introduced by defense counsel as proof that the perpetrator who had left his DNA at the scene of the crime was not, in fact, the person who is now accused of the crime. Put another way, DNA analysis was not only strongly scientific, but also neutral in the sense that it could be used to establish either guilt or innocence. It was for the latter purpose that in the early 1990s, chiefly by the work of the Innocence Project, founded in 1992 by professors Peter Neufeld and Barry Scheck at Cardozo Law School, that there began to be a whole series of proofs that people who had been convicted beyond a reasonable doubt of very serious crimes, usually murder or rape, were in fact innocent. Indeed, to date, nearly 600 people have been exonerated by DNA testing that proved to a very high probability that these people had been convicted of crimes they never in fact committed. This was itself mind-boggling to some judges. The typical judicial attitude prior to such exonerations had been famously expressed by Judge Learned Hand, who wrote in 1923 that, quote, "Our procedure has always been haunted by the ghost of the innocent man convicted. It is an unreal dream," close quote. But DNA evidence has demonstrated definitively that Hand was wrong. And this, more generally, made some judges less sure that the criminal justice system was working the way it should, at least so far as forensic science was concerned. A further byproduct of all this arose from the fact that many of those wrongful convictions, according to the Innocence Project, more than half of those exonerations, the convictions had occurred in trials where other forms of forensic science had been introduced by the prosecution and played a major role in the conviction of guilt. Among some, but as we'll see shortly, not all judges, this occasioned a dawning recognition that at least some other forms of forensic science might not be anywhere near as reliable as previously believed. The second major development, more or less contemporaneous with the introduction of DNA into the criminal justice system, but unrelated to it, was the U.S. Supreme Court's groundbreaking decision that you've heard so much about in Daubert versus Merrill Dow Pharmaceuticals. Incidentally, while some people pronounce it Daubert and a few snobs say Daubert, it is, according to Mr. Daubert, he says his name is pronounced Daubert and he ought to know. Anyway, as you may have already heard earlier today, prior to Daubert, both state and federal judges determined whether or not to admit scientific evidence in jury trials, both civil and criminal, by reference to the standard first developed by the D.C. Circuit in the case of Frye versus United States. The Frye standard held that scientific evidence could not be admitted unless it was deduced from a scientific principle that had gained, quote, general acceptance in the particular field in which it belongs. Although this sounds like a tough standard, and Frye itself used it to exclude what is now known as polygraph testing from the federal courts, and indeed it's been excluded by all the courts in the United States except New Mexico. In practice, determining the particular field became so difficult that it was often defined narrowly to involve only the practitioners of the particular forensic practice involved. So, for example, there are cases under Frye which says that fingerprint evidence is admissible because it is generally accepted in the fingerprint examiner community. Duh, I mean, come on. Nevertheless, until Daubert came along, the Frye standard had been adopted in every jurisdiction, state and federal, in the United States. But the Supreme Court in Daubert, based on the court's interpretation of Rule 702 of the Federal Rules of Evidence, put additional burdens on federal judges to determine just how reliable the proffered scientific evidence and the scientific theory on which it was based really were. And by the way, a lot of Daubert, as I think was mentioned earlier, came from an amicus brief introduced in that case by the AAAS. They should be very proud of the role they played in educating the Supreme Court as to what science is all about. After Daubert, a federal trial court determining whether or not to admit scientific evidence typically has to look at whether the proffered scientific evidence is based on a scientific theory that has validity because it has been tested and peer-reviewed, and a scientific methodology that is reliable because it gives consistent results and does not result in a high rate of error. This is all in addition to the Frye test, which is still part of the Daubert analysis, whether the principle is generally accepted in the relevant scientific community, but under Daubert and many of the cases following it, the relevant community has been defined much more broadly than previously. Now, while there's no indication that Daubert, which arose in the context of a civil toxic tort class action, was influenced by the doubts that DNA testing had raised about forensic science methods, Daubert on its face was directly applicable to the admissibility of all scientific evidence, including forensic science. Moreover, while Daubert was a federal case, the Daubert standard proved to have great appeal, and it has now been adopted by 37 of the 50 states, and even in some of those states that have not adopted it and adhere still to Frye, it's had an impact on how they determine or how they apply Frye. Both the advent of DNA evidence and the promulgation of the Daubert standard also led to the third major development, which was that Congress in 2005 authorized the National Academies of Science to conduct a study of forensic science. The National Research Council arm of the National Academies promptly undertook such a study over the next 4 years, and the result, which I submit also had a substantial impact on some, but not all judges, was the publication in 2019 of a 314-page book entitled Strengthening Forensic Science in the United States, authored by a distinguished group of scientists and law professors and co-chaired by Harry Edwards, a very great judge of the DC Circuit. The NAS report, as I'll refer to it, strongly suggested that many traditional forms of forensic science, such as bite mark analysis, tool mark analysis, hair analysis, and even to some extent fingerprint analysis, were not good science at all. Many of these techniques had never been scientifically tested, let alone peer-reviewed, and nearly all of them used methodologies that were highly subjective and potentially unreliable. For instance, the NSA report found, quote, no scientific support for the use of microscopic hair comparisons to match individuals, except where the hair samples contain DNA that could be independently tested and compared. In addition, the report found a high degree of variation in the training, quality control, and standards of the forensic laboratories throughout the country that were and still are the main source of forensic science introduced in court. These are mostly police labs. Some are still part of the police departments. In other locations they are not, but they all work very closely with the police. It should also be mentioned that the President's Council of Advisors on Science and Technology, sometimes called PCAST, expanded on the NAS report in its own 2016 report and emphasized, among much else, the alarmingly high error rates of many traditional forensic science techniques. Now, one might have thought that these three major developments, the advent of DNA, the determination by the Supreme Court in Daubert that more judicial oversight was required, and the study by the National Research Council casting doubt on much of forensic science, would have had a major impact on the decision of judges to allow or not allow conventional forensic science to come into evidence. But, in fact, the reaction of judges has been one extreme or the other, with very little in between. For example, in one of the first federal cases to apply Daubert to microscopic hair analysis, Williamson versus Reynolds, which is a decision by a very fine judge, Chief Judge Frank Say of the Eastern District of Oklahoma in 1995, Judge Say granted habeas relief to a death row defendant who had been convicted of murder based on expert testimony that 4 hairs found at the scene of the crime were, quote, consistent microscopically with the defendant's hair. After a lengthy hearing, Judge Say concluded that microscopic hair analysis fails to meet any of the requirements of Daubert. Among other things, he concluded that microscopic hair analysis is highly subjective, lacks any consistent standards, produces erroneous results in over 2/3 of the tested cases, and is frequently influenced by extraneous bias. Moreover, as Judge Say stated, quote, not even the general acceptance standard is met, since any general acceptance seems to be among hair experts who are generally technicians testifying for the prosecution, not scientists who can objectively evaluate such evidence. Now, Judge Say's opinion received wide publicity and was even, as some of you may know, the subject of John Grisham's nonfiction book, The Innocent Man. Nonetheless, less than 5 years later, in one of the states that had adopted the Daubert standard, the Supreme Court of Kentucky reached the wholly diametrically opposite result in the case of Johnson versus Commonwealth, a decision of the Kentucky Supreme Court in the year 2000. In Johnson, the trial court, though confronted with Judge Say's opinion in Williamson and supporting evidence for the doubts expressed there, refused to even hold a Daubert hearing, but instead allowed the state's expert to testify at trial that a hair found in the dead victim's hand had been determined to have the same microscopic characteristics as the defendant's hair. Affirming that result, the Supreme Court of Kentucky held that no Daubert hearing was necessary because the scientific reliability of microscopic hair analysis had been so long established that, quote, trial judges in Kentucky can take judicial notice that these methods or techniques have achieved the status of scientific reliability, close quote. By the way, for those of you who are not lawyers, judicial notice is supposed to be something that is absolutely incontrovertible. I'll get it right. Now, clearly, the results of these two opinions that we've just discussed are irreconcilably inconsistent. But it gets worse. On the one hand, following Johnson, several state courts and jurisdictions that had supposedly adopted the Daubert standard nevertheless held that no Daubert hearing was necessary before the government could introduce microscopic hair analysis because the scientific basis for such analysis was too well established to be subject to judicial scrutiny. For example, in the Connecticut case of State v. West, a 2005 decision of the highest Connecticut court, the defendant had sought the Connecticut version of a Daubert hearing based on the many doubts about microscopic hair analysis that had been raised, not least in the NIS report, but the Supreme Court of Connecticut affirmed the lower court's denial of a Daubert hearing because, quote, the validity of the methodology underlying microscopic hair analysis is well established, close quote. For this dubious proposition, the court relied on Johnson and, beyond that, simply on cases decided prior to Daubert under the Frye standard. What it shows, among other things, is that the dead hand of Frye is still very much alive in Connecticut and other states that claim to have adopted the Daubert standard. Yet the sad truth is that numerous persons convicted on the basis of microscopic hair analysis continue to be proved totally innocent by post-conviction DNA analysis. Thus it was that around 2014, following the DNA-based exoneration of 3 defendants who were convicted on the basis of FBI microscopic hair analysis, the FBI itself agreed to undertake, in coordination with the Innocence Project, a review of some 3,000 cases in which the FBI's own experts had provided hair-matching expert opinions favorable to the prosecution. The results of that study, first released in 2015, were that the FBI's experts in those 3,000 cases had provided either wrong or at least materially exaggerated testimony in over 90% of those cases. As a direct result of this study, numerous federal convictions were reversed. For example, in United States versus Butler, the District of Columbia in 2020 reversed a murder conviction in which the defendant had already served 50 years in prison. But as the court noted, quote, the government now concedes that the hair microscopy evidence presented against Butler was false and exceeded the limits of science. The government also acknowledges that the prosecution knew or should have known of the hair microscopy evidence's inadequacy at the time of trial, close quote. So, what we have just discussed about the blatantly different and inconsistent treatment of microscopic hair analysis given by courts of different U.S. jurisdictions is just one example of the blatantly different views that different courts in the United States have taken toward the various forms of forensic science that the 2009 NAS report and the 2016 PCAST report identified as unscientific. And it also needs to be noted that even those courts that apply the Daubert standard faithfully in civil cases often decline to do so in criminal cases. For example, late last year, Nathaniel Chuck, one of my research assistants at Columbia Law School, undertook a survey of the then most recent 300 federal cases, civil and criminal, in which Daubert challenges to the admissibility of scientific evidence had been the subject of reported opinions. In civil cases, nearly a quarter of the Daubert challenges made by either side were successful. But in criminal cases, less than 10% of the Daubert challenges made by defendants were successful, although over 90% of the Daubert challenges made by the prosecution were successful. Sounds awfully like a double standard. And in many of those cases where the defense challenges were held insufficient, there weren't even Daubert hearings, even in federal court, because the courts referred back to precedents approving such evidence from the Frye period, as if Daubert had not changed anything at all. Of course, the results of that very brief survey are open to alternative explanations. For example, it might be argued that the results simply suggest that the scientific evidence offered by the government in federal criminal cases is better than the scientific evidence offered by private parties in civil cases, which is why Daubert challenges made by the defense in federal criminal cases almost never succeed. But that suggestion is almost certainly wrong, as what the government offers in federal criminal cases, let alone in state criminal cases, mostly consists of the forensic science evidence that the NAS and PKS reports show, at least to the satisfaction of many judges like me, that they are scientifically suspect. A more likely explanation is that because of the high stakes in criminal cases, judges are reluctant to derail such cases by throwing out what appears to be key evidence of guilt, preferring to leave it to the juries to sort things out. Some might even suggest that many federal judges who, like me, were former federal prosecutors, are reluctant to exclude the kind of evidence that they as prosecutors routinely introduced. But whatever the explanation, it accords with the general perception by many observers that courts, both state and federal, remain reluctant to exclude even those kinds of forensic science whose accuracy has been so severely questioned over the past few decades. More generally, and regardless of the kind of scientific evidence involved, whether forensic science or other science, and regardless of the kinds of cases, civil or criminal, in which such evidence is offered, the more fundamental question, which I know has been the subject of many of the panels today, is whether judges are equipped to deal with scientific issues of any kind. Very few judges have more than a very limited scientific training. In college, most of us were history majors or poli-sci majors, or as in my case, an English major. We had that one course freshman year, the required course. Most of us took geology. I took something that was referred to by the other students as physics for poets. It was a great course, but didn't exactly make me a hard scientist. Yet, as I already noted, science in one form or another has become a factor in a great and increasing number of legal disputes, not just those I just mentioned, but by way of just a few examples, global warming disputes in environmental cases, genome patent disputes in intellectual property cases, drug defect disputes and mass tort actions, the disputes about the role of artificial intelligence in determining bail and sentences in criminal cases. I could go on and on. And because dealing with scientific issues does not come natural to most judges, they inevitably, in my view, seek to avoid dealing with such issues, whether by relying on administrative agencies if the case originated at the regulatory level, or at least in the patent area by having specialized courts like the Federal Circuit, which has exclusive jurisdiction over patent cases, or by just ducking science issues wherever possible, either by deciding a case on other grounds, or, as mentioned, by leaving the issue to the jury, which of course typically consists of people who have even less scientific expertise than most judges. Now, as I know you've heard, some academicians, such as Professor Chang of Vanderbilt, have urged, in effect, the repeal of Daubert, and although he disclaims this, in my view, really a return to a Frey-like reliance on scientific consensus. But quite aside from the enormous difficulty, which again I suspect you've already heard about, in determining whether any given item of scientific evidence conforms to, quote, scientific consensus, I think in some ways this return to Frey approach not only sells judges short, but also creates more problems than it solves. Whatever its good intentions, Frey unquestionably opened the courthouse door to what can only be called junk science by permitting judges to avoid meaningful scrutiny of such evidence by simply invoking formulaic recitations that it was generally accepted. And once a court had so found, it was even easier for later courts to simply rely on that determination as binding precedent. By contrast, Daubert, while it demands that judges actually take a hard look at the scientific evidence being offered in the case before them, at the same time, in my view, calls upon judges not to play scientists or to guess at what might be generally accepted in the allegedly relevant community, but simply to determine that what Daubert requires are basically determinations of fact, something that judges do all the time. Consider the four factors most often in dispute at a Daubert hearing. Whether the underlying scientific theory has in fact been tested, whether it has in fact been peer-reviewed, whether the methodology resulting from the theory has been applied consistently, and whether its use has or has not resulted in a high error rate. These are factual disputes, not, in my view, particularly requiring scientific expertise to resolve. You don't need to be much of a scientist to determine whether a particular scientific principle is still just a theory or has been the subject of testing and peer review. And if the latter, whether the resultant methodology has been applied consistently and has resulted in a high or low error rate. If the Frey standard in practice too easily widened the courthouse door to bad science, who but the courts are authorized to narrow that door, and doesn't Daubert provide a way of doing so that is well within the ordinary judicial function of fact-finding? If more judges understood this, I think they would be far less reluctant, as they are in so many cases now, to avoid dealing with scientific issues. So let's turn to ways to help judges and other players in the legal process deal more comfortably and effectively with scientific disputes. A slew of proposals have been offered, some of which you heard with the last panel and perhaps earlier panels that you heard from before I arrived. These proposals have included, for example, creating an independent board of scientists to examine the reliability of various scientists, or creating a science court that would have exclusive jurisdiction over cases that were fundamentally dependent on assessment of scientific issues, or encouraging judges to refer scientific issues to court-appointed experts or special masters, or make use of technical advisors and so forth. A different kind of proposals that have been made include everything from greater circulation of the existing judge's reference manual on scientific evidence to a mandatory scientific training for lawyers and judges to a more demanding standard for appellate review of scientific determinations by trial judges and so forth. And the third set of proposals looks to Congress and the executive to help make things better by, for example, reviving the National Commission on Forensic Science, which I had the great privilege of serving on for 4 years before it was terminated by Donald Trump, or creating similar committees for other kinds of science that interact with the courts. Each of these proposals has both positive and negative aspects, but I'm going to duck for the moment because rather than detailing the debate right now, I'm going to end my prepared remarks and ask Theresa to come back up, and she and I would love to have questions from all of you on how we can improve this situation. But the main point I'm trying to make, which I will repeat once again, is what we have today when it comes to how courts deal with scientific issues is such blatant inconsistency, such blatantly irreconcilable positions, that it not only can't be called good scientific analysis, it can't even be called the rule of law. Thank you very much.
All right. I did it on the first try. We've had problems with the microphones all day.
How clever.
So I know that all day we've been cutting the Q&A short, so I'm going to make sure that we have time for Q&A before we go out to the reception for the end of the day. But so we'll get started, and please come to the microphone. We'll start lining up so that we can start taking those questions. I think you outlined the problems and the some of the solutions very nicely. I'm curious, one of the conversations earlier today was Ron Allen talking about how we're trying to solve a substantive problem with process, with procedural solutions. And I'm curious for what your response is to that.
Well, I'm sorry I didn't hear what he had to say, and so this is more just a quick off the cuff. I think one of the things most people learn in the first year in law school is that the distinction between substance and procedure is vague, and that the two overlap, and that many a substantive decision is made in the vein of procedural determinations. So I would need to know more specifically what he has in mind. But what I was trying to say before, and I'll repeat is Daubert requires basically fact-finding by the judge. In that sense, it's substantive, not procedural. It's only procedural in the sense that it's to determine admissibility rather than make a final determination. But fact-finding is something that judges do day in and day out. And in my experience, I've had now, I don't know, many dozen Daubert hearings. It's not that hard to find out whether this theory has been tested, whether this theory has led to peer review, and if so, what has been said in the peer review. This doesn't require, in my view, scientific training. It's a factual issue. Has it been tested or not? Counsel, if it's been tested, show me the test, show me the report. Has it been peer reviewed by someone who was not associated with the person who did the original study? If so, show me the article and I'll read it. Error rate is often more difficult to determine, as often it hasn't been determined, but where it has been determined, then, if it's a 30% error rate, most judges would have strong reason for not holding that sufficiently reliable. So without multiplying examples, I wouldn't make a substantive versus procedural distinction. I would say the issue is whether judges can come to recognize and fulfill their obligation to make fact-finding in these areas outlined by Daubert.
I'm going to hold my questions and take questions from the microphones. Let me start over here.
Thank you very much. That was a fantastic overview of a dire situation. I'm glad I'm not in law. I am at Georgetown University, but I'm a professor on the medical center campus. And so I'm involved in curriculum development in higher education and postgraduate education and training. And I wonder if you think priority should be put on training people who may go into law. People who may go into law, so the undergraduates who, for example, are not in science because they're already getting science training, but the other disciplines maybe take the one class in science, or should resources be directed specifically at law schools that generate lawyers and judges, or should they be more distributed so that any lawyer or judge, let's say we only have one pile of money and no magic wand from the last, because it was used up in the last session. So where would that pile be best?
Well, do you think? This is not wholly responsive, but of course that's the prerogative of a judge. When I had the very great privilege of serving on the board of Swarthmore College, my alma mater, and I suggested that in addition to that first year mandatory course, that people in their junior or senior year be required to take a course in science as applied to more immediate issues like environmental issues, for example. Because if you're really a liberal arts college, you need to equip your students with that broad knowledge in the current world. My proposal was soundly rejected because it was, quote, too expensive. but I still think it was a good proposal, and maybe Williams or Amherst will take it up even if Swarthmore won't. So.
Judge Rakoff, as I expect you're aware, the National Institute of Standards, first in conjunction with DOJ and since Trump on its own, has been convening groups of representatives, I think 24 different forensic sciences, who are charged with setting standards for their sciences. The standards are quite diverse. They range from highly technical ways to do a certain flame test, to standards for training, to standards that say that a forensic scientist in this field can or cannot testify in this way, to standards for labs who avoid cognitive bias, and the like. It's been a painfully slow process, but things are emerging and are appearing now in the NIST registry. So I have two related questions. One is, are you encountering references to any of these standards when your work with scientific evidence? And the other is, do you see this kind of official standard pronouncements by NIST, standards that have been developed by actually forensic scientists in the different fields, as having a possibility of going a long way to dealing with the kinds of issues that have troubled us today?
So, first, you are quite right to point out that NIST has done some excellent work. And I'm sorry to report that it is very, very rarely referred to by counsel in the cases before me. This comes back to the education question. In an adversary system, there's limits on what a judge can do. And we discussed earlier, Joe Cecil was saying maybe we should take a more hands-on approach. But in any event, if the NIST standards aren't being raised by either side, there's a limit on what a judge can do. So they've been doing excellent work, but I haven't yet seen much impact.
There's actually been most of the work is still to come.
Okay, well, no, but I've seen some good things to come out there. Now, their jurisdiction is limited as to certain issues. I'll give you an example. When the National Commission on Forensic Science was in existence, a controversial issue was whether the prosecution in federal criminal cases had to give the same kind of advanced discovery of their experts as would be required in an ordinary civil case. And ultimately, the commission, by a vote of well over 80% of the 32 commissioners, voted in favor of that, and the Department of Justice adopted it, and it's now also been largely adopted as part of the federal rules of criminal procedure. None of that could be done by NIST. That had to come from a different perspective, a different power base. But I don't want to take away from the very good work that NIST has been doing.
Your Honor, thank you so much for coming today. I had a similar question. I know that the PCAST report had some very good conclusions about doing research in both black box studies and in new technologies that could help forensic scientists make better conclusions. And there's been a lot of publications since that report has come out. Have you seen or heard of these peer-reviewed publications being used in the courts? Some of them, a lot of work has been done by academic institutions, some of them partnering with crime labs, and some of them published in, I think the latest one was in PNAS, actually, I think by Iowa State, so a very reputable journal. I'm just curious if you're seeing that yet.
Yeah, I am not, but I want to qualify that statement. I do see more recent developments and newer research much more often in civil cases than in criminal cases. And why is that? It's because the parties are richer. So if you have two big companies fighting each other, or even if it's like a classic class action where it's a class represented by a familiar plaintiff's class action firm that takes on big cases versus one or more large corporations, they have the money not only to hire good experts, but to make sure that the experts spend the time to be fully up to speed. And so then I get to see it when we get to a Daubert hearing, almost never in a criminal case. Never because on the defendant side, they don't have the money. Most criminal defendants are indigent or close to it. And on the government side, because to be frank, they've not been very challenged by most judges so far, so why should they worry about the new stuff? But in the civil cases, I do sometimes see it.
Thank you.
Hello, I'm Allison Renteln from USC. I wanted to thank you for your incisive analysis. So eloquent, it's a joy to listen to you. I was wondering about the international dimensions of this topic. You've done, I believe, a great deal of teaching of judges in other parts of the world, and the AAAS has been doing so much work on the right to science as a human right, and I've heard Theresa give a brilliant lecture on that subject. I wondered what kind of impact the Daubert, how is it pronounced, Daubert decision has had in the places that you've visited when you've taught judges, and I wonder if there are things that you think we should take from those legal systems to improve our own.
So I'm sorry to have to say that we have to distinguish here between rich countries and poor countries. In many rich countries, England, France, so forth, there has been greater attention to some of the issues we've been discussing in this conference than there even has been in the United States. And so, for example, as I think was alluded to in the last panel, the judges in the UK bring very strong pressure on the parties to select a single expert between them. In Australia, as I know you heard, they have hot tubbing. I think I'm not precluded from trying that out. I don't think it requires legislation. Anyway, I'm tempted to try it. But in any event, in Australia, it's the norm. So there have been great advances. I spent last week in Bangladesh. People were lovely. It was a very interesting country. The notion that they would even get into issues like this is overwhelmed by the fact they have a judicial backlog that is huge. This is true of India and Pakistan as well. It partly goes back to good intentions in all those countries which were part of the British Empire, adopted a very lenient appellate right. So, for example, we're used to the Supreme Court taking 100 cases and not taking 1,000 others. In India and Bangladesh, you have an automatic right to go all the way up to the Supreme Court regardless. They can't say no. And the result is that they are the typical case in the Supreme Court of Bangladesh takes 7 years just from the time it reaches the Supreme Court to the time they issue their decision. So stuff like we've been talking here is to them a non-starter because they have so many more basic issues that they have to unfortunately deal with.
Yes, Your Honor, thank you. Patrick Coyne, I'm with Finnegan here in town. My first 11 trials were Benedictine cases, which Daubert is one of them. I didn't try the Daubert case, but we were benefited from it because the DC Court of Appeals reversed the 2 jury findings we got before Daubert came down under the Frye standard. So I appreciate the improvement that it's offered, but I also agree with you. It is incredibly inconsistent. It varies from district to district and judge to judge, and sometimes even day to day. So my question for you is that, I also do appellate work, and I think part of the problem is that it is a fact-finding, which means it's entrusted to the sound discretion of the trial judge, which the Court of Appeals is only going to overrule for clear error, which means, for example, I used to do commercial litigation for 20 years. I think there were a lot more variability, a lot more garbage science being thrown into the court in mass tort cases, in class action cases. Now I do patent cases. I see a lot less garbage science being thrown in, yet I see Daubert motions in every single case by both sides, often challenging every single witness who's put up. Seriously, everybody is that bad that they should be struck? So, and what happens is some judges just throw out everybody and say, come back to me with more detail. Some judges let them all in. And you're right, it's a train wreck. So, but what can we do? So legislation's not going to happen. This Congress isn't going to do anything. And we could go to the Federal Judicial Center, you could go to the Judicial Conference, but this is way down on their list of priorities given all the other problems in the system. But what could we as the private bar, as an association of scientists, as the ABA, other bar associations, what could we do to help make this situation better, more consistent?
So I think that's a terrific question. By the way, you are quite right that in civil cases where the parties can afford it, they'll challenge everything under Daubert. But you know, they would do the same under any other standard. It's just part of the adversarial system. I do think that we should change the standard of review. The Supreme Court has held that a trial court's Daubert decision can only be reversed for abuse of discretion. And of course, as a district court's, in theory, I love that. But in fact, I think it doesn't make sense for this reason. The reason for an abuse of discretion standard in most situations is because the judge or jury has seen the witnesses, sees their demeanor, knows whether they're credible or not, things like that. On these kinds of issues, it's usually a paper record, and the Court of Appeals is in just as good a position as the district court to evaluate it. But since it's an abuse of discretion standard, you get them approving inconsistent results below, and so you never get a standard set for that particular circuit, for example. So I would change it to a de novo review.
Well, as I had hoped, you all asked all the questions I had on my paper. So thank you very much. Was there anything that you wanted to say that a question that didn't get asked?
Well, I think the question in my mind, I'm sure most of your mind, is I hope those stacks are still waiting for us. So let's get to them.
Thank you so much. Thank you, Your Honor.